Hi, I'm Debbie Moraes, and this is Legal Matters, the program that's been designed to address the critical, sometimes contentious matters that are facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics that affect your home and your work life. The program has recently covered such topics as adoption and sexual abuse and sexual harassment, surely the heartwarming as well as the heart-wrenching. Today we are going to discuss a topic that hits home right here in Rhode Island, a lawsuit involving the First Amendment and the press. So we have a special guest today who we'd like to welcome. Our special guest today is Froma Harrop from the Providence Journal-based, nationally syndicated columnist and currently president of the Association of Opinion Journalists, formerly known as the National Conference of Editorial Writers. Welcome, Froma.
Thank you.
And also, as always, we have with us from Odette Bizarre Cadero Grasso Law Firm in East Providence, David Bizarre.
Thank you.
We wish Jackie were with us next time, hopefully. So, as they say, ripped from the headlines, the popular phrase goes, local press file free speech suit, specifically the Rhode Island Press Association and the publisher of the Warwick Beacon filed suit challenging a state law that has been interpreted to ban the media from running advertisements containing the names, the likenesses, the photographs of public officials without their permission. So here's the setup briefly of the story. A Warwick resident placed an ad in the newspaper criticizing the city council president and the mayor about vehicle taxes and included their names and their photos. It was called the Car Tax Revolt. First, Warwick City Council members threatened to sue the Beacon over the ad placement. They claimed that the publication of the advertisements containing their names and likenesses would provide grounds for a civil action, a violation of Rhode Island general laws. The Beacon and the press say the law is unconstitutional on its face and it violates the First Amendment. Legal counsel for the Rhode Island ACLU contends the state was not meant to cover political advertising, but rather in relation to the sale of products and services, and that statute is unconstitutionally vague. They're seeking declaratory judgment and costs. So, let's begin. I guess we should begin with our legal counsel. David, why don't you briefly explain First Amendment, even though we've tackled that before, especially as it pertains to this.
Okay. Well, let's start with the statute that's in question here.
Okay.
The statute that's in question involves whether or not someone can use someone else's name, likeness, or information about that person in a advertising or commercial setting. And that derives from the right of publicity, which is you can't misappropriate someone's name and use it to endorse a commercial product. So the statute's really designed to protect against someone's name being misappropriated in a commercial setting. So I think if you look at the statute and the purpose that it's set for, a court could interpret it to say that does not include non-commercial use or political discussion, because the First Amendment is a defense to that misappropriation, the First Amendment being the right of free speech and the right of a free press.
And free speech and free press, you represent the editorial side of it, and much of your work is political. How about if you weigh in on this, Froma?
I think it's political speech. I think that ad is undeniably political speech. It's not attractive political speech. I don't particularly like the form the ad took, but I don't see how you could ban that. And frankly, as the political discussion of this nation moves onto the internet, where there are no controls at all about how people can use your image, I don't see how they can deny this person the right to use the images on that ad.
Now, if it were you and you were writing a story, editorial or it's news gathering, different story, it might still be in bad taste to put the person's name and number if he's a mayor or a city council person, but they're allowed to do that. It's news, isn't it?
Absolutely. The Providence Journal has a lot of editorials and columns in which we say, if this bothers you, call Mayor so-and-so's office at this number.
I agree with Froma in a lot of different areas, but we're talking about this particular ad. I don't like it. It offends me. But that's the whole purpose of the First Amendment, to protect somebody's right to have a political discourse, to have a discussion, to say things that are either unpopular or popular, but to protect the right to do that. And so when you have a statute that's involved, that's talking about not misappropriating someone's name for commercial purposes, that's got to be very narrowly construed so that you look at the use of the name and the context in which it's being used to determine whether there's a violation of that statute.
You study and you certainly serve in Rhode Island. Is this one of these stories that's among the cadre of only in Rhode Island kind of stories where Rhode Island has this problem, this issue that's being, it's now a lawsuit? Because certainly other states have been able to do this, and when we've talked to the ACLU lawyers, they can't cite what other states allow it, but is this a peculiarity in Rhode Island?
Well, I think there's at least 28 or more other states that have these publicity statutes. I think they're actually much more used in California and New York, where you have actors, actresses, sports people whose names sometimes get used in connection with a product that they didn't want to be associated with. And so there's much more case law in California, for instance, on these statutes. But I think all of those states have narrowly defined the use to commercial issues, not political speech.
And of course, the political issues have their own broad-based and new set of rules and regs that we can discuss later. But the ACLU lawyer made two arguments about this lawsuit, and you cited one: the statute wasn't meant to cover political advertising. But was this a matter of him, the sponsor, just saying, I really want you to vote this person out of office, which is what one of those ads said, or is there really just an issue about, I'm trying to make it easy for you to know, dear consumers, that if you want to go call your lawyer, your mayor or your city council, here, I'm just making it easier for you to do this. You're just being a good servant, a good public servant. Can they just do that? Is that really political, David?
Anything that has to do with the democratic process, contacting your representatives, saying I am not in favor of electing somebody, is political. I actually think, though, our Supreme Court may have gone a little over the edge on what political speech is when they say spending money is political, which has resulted in these super PACs. I think that is beyond the scope of what political speech is, because then you get into whoever has more money buys more ad time and can do that. I think it should have been limited to the protection of the people's rights to be part of that process. But in this context, clearly somebody who has something to say about our democratic process is acting in his right to exercise his political free speech.
And they say that this law, as it's written, the reason they're taking issue with it, David and Froma, is that it's too broad, too all-encompassing. Do you think that this really does need to be made more specific and more clear so that these things either can be done or clearly can't be done?
When you
I'm not a lawyer, and so I'm not sure about that, but from what I understand of the law, it says you can't use someone's likeness for profit. And this is
Right.
not for profit, so it doesn't seem like, it seems like a slam dunk to me,
Right.
frankly.
I think it's pretty clear on its face. I think the Beacon, was it the Beacon that had this
Yes.
particular case?
Yes.
Their concern is, if we go ahead and do it without knowing, are we opening ourselves up for a lawsuit? And we want to know up front what's correct and what's not correct. They could have certainly run with this, taken the chance and said, sue us, but who wants to go through that process necessarily?
Well, of course, you representing the Providence Journal, if this were brought to your attention, you could not only have the courage of your convictions, but with BELO backing, you certainly have a lot more money than most smaller papers, and in this case it's pro bono with the ACLU, but
Yes.
the Providence Journal with BELO behind it could certainly defend its case and have the money to slug it out.
Well, we certainly have more resources to do that sort of thing than the Warwick Beacon, and that's why ACLU is doing good work here.
And I think
Yeah.
maybe this one really pertains to you to make a comment. Publisher John Howell from the Warwick Beacon said, if this were allowed to stand, this law as it is, it would seem that political advertising could become the subject of litigation that could stifle public discourse and give the candidate with the greatest resources the ability to suppress criticism. Opposition ads happen all the time. Comment?
Yeah, and they get pretty darn rough, and as we approach November of this year, we're going to see ads a lot rougher than the one from the Warwick Beacon. I want to say again, I don't like that ad. I think it's sort of chilling on the civic culture. I think these are a council president and a mayor. They're elected. They're trying to run this town. I think there's a certain, civility involved.
You have civility promise.
Yes, I know.
Civility
I
issue.
think there's an issue that you want your local government to function, and so you're a little careful as to how you register your complaints. I am actually quite sympathetic to what this ad seeks to obtain, because I hate the car tax, but the way it's the advertiser has gone about it is really unfortunate.
And again, I agree. I don't like the way it's done. I actually don't like paying car taxes either. But I don't think it's necessarily the fault of the two people who are pictured in that ad. They're trying to do their jobs. They're trying to work within the law and balance their budgets and do all of that. I don't like negative advertising to begin with. I'm an optimistic person. I don't like negativity. But I guess it works to some extent because they wouldn't be doing that throughout the course of politics. And it's happened since advertising started before the country probably started.
Well, speaking from the advertising camp myself, as one who does this for a living, I know we've come a long way from the time when you could only refer to brand X and never say, this issue, I'm better, that guy is bad, and here's how and why, and name him. But of course now, Romney, I'm sure, never gave Newt Gingrich permission in the political arena to use his likeness, but political ads, I guess we have to make a distinction, they have their own distinct realm. Do they not?
Because it's protected under the First Amendment, so it absolutely does.
And yet, if this man who put the ad, first placed the ad at the Warwick Beacon, if he had been a car salesman and he is leading the car tax revolt, might you then defend this as it is because he might have something to gain if he could sell more or less of his automobiles? Would that be of a gray area?
Yeah, I don't think so.
No.
Because it's what is the context and use of the ad and what is he trying to do?
Right, he's not saying Mayor Avedian is buying my cars,
Right.
Loves my cars. That would be different, but I think context also matters. I think just in terms of our public civic culture, what you do in the fishbowl of a small town or a small city is a little different than what you do nationally. Nationally, it's a big brawl. But when you're dealing with people you see in the supermarket, on the streets, you want to have a certain comedy, not comedy,
Right.
in your town. And so this ads like these are really not helpful, I don't think.
But then again, you can't legislate good taste. That's another issue entirely, right?
No, I'm not saying that, no.
Now, they did initially threaten a civil suit. What would that have been?
In terms of...
Of that, pulling that ad?
Tell me.
If you don't fix that ad, we're going to sue you.
You're saying the people who are in the ad?
The people who are in the ad, the
The councilman? Okay. So what the councilman is saying is that there's a statute in Rhode Island that says you can't have an advertisement with my name or likeness without my consent, and you don't have my consent. But I think his reliance on the statute's misplaced, because I think if he had brought that suit, instead of the ACLU bringing the suit they did, a judge would have, at least if I were the judge, I would have said, no, that's not the purpose of this statute. They're not saying you endorse this position, that there's some money to be made for them, but rather that this is political discourse, and it's not protected by that statute.
It's free speech. Now, speaking, if you think about John Howell as a small businessman, he's seeing that there's a perceived threat. The ACLU sees this as a historic issue. Is it somewhere in between? Do you think that John Howell did this because he wants to avoid additional suits? He wants this settled once and for all so he can continue to obtain ad money?
Well, I think that, wouldn't you say?
Yeah, well, I think he has a right to obtain
Right.
ad money.
Right.
If he has a right to accept an ad that is legally okay.
Right. And so he's saying that it's talking about historical, what did you call it,
Historical importance? Or
importance,
historical-
because of its impact on the First Amendment. That's absolutely true. But it's also I don't want to be in the position that I have these kind of ads in the future, and I'm threatened with these lawsuits.
And right now, that suit is with the AG, in the AG's office. The AG because he doesn't agree with it, or does agree with it, or is it just that he, as the AG, has to represent the state law as the state law is?
Anytime a statute is challenged on constitutionality, those grounds, the AG is given the job of protecting and preserving the laws that the state of Rhode Island has passed. So if you have any case that brings up the issue of a constitutionality of a law, the AG has to be brought into the case.
And then subsequent, I don't think this is happening concurrently, but there was a discussion that however this plays out, it's likely to need the legislature to change that law if it's supposed to be changed, clarified, or however. Would that not take, how would that take place? Would that take place while this suit is underway, or would they necessarily wait till the disposition and the judgment on it?
There's two ways this can play out. This law could be found constitutional. At the same time, the judge could say that it's inherent in the Constitution that the law is narrowly construed to only apply to commercial settings, and that political discourse does not fall under that. So therefore, the law can be found constitutional, but at the same time, he can write a decision that says the use of this statute doesn't apply to people whose pictures or names are used in political advertisement.
Fair enough. I do understand from John, though, that at least right now, no legislation is being posed. I think they're, as you said,
They're waiting
for
and
a
see.
shock or two,
Sure.
or the next state. Model releases, very different from what was going on when the sponsor of this ad decided to take the mayor's and the council president's picture and put it in. If someone were actually going to be doing that as a commercial venture, as those in my field do, it is pretty typical that you do present to them a model release, and they have to give their consent that they can use that photo. But does it always mean that that photo can be used just in only the one way in which you have seen or thought that it was going to be used? Because clearly, Mayor Avedisian must have allowed them to use that photo at some point, but not necessarily for that application. So there's an issue on the table now about how it's being applied. When someone signs off, David, do they have to sign off on every use, every application?
So the statute that we're talking about says that you can't use someone's name or likeness in a commercial setting without their consent. So releases are drawn. Many times, people go to a photographer and have pictures taken, and they sign releases saying that the photographer can use it in some form or fashion. If it's a broad release, the photographer might be able to use it in conjunction with some other kind of advertising that he's involved with. You have to be careful to read what you sign for a release. If it's very narrowly worded that it can only be used for that particular photographer's personal advertising, you know, these are the types of pictures that I can do, and then used for something else, that might go beyond the consent that was given. So in this particular case, I don't think the release would have anything to do with it, because Mayor Avedisian would never have consented to use it for this purpose, but it can still be used for this purpose because it's not used in a commercial context.
Good.
And I imagine someone could use a photo a lot less flattering than that, too.
Right.
I mean, someone could take a photo of him, you know, falling in a puddle or something and looking bad, and use that.
Right. And isn't that, I know you talked about it on a national scope, but I know I've seen advertisements in the political arena where they take somebody's picture and distort it and do all sorts of stupid things to it, and
Frequently.
I really am bothered by that, but it's done.
I know in this particular suit, and this discussion about model releases specifically is a little bit off target, but it does pertain to others who will have to sign a model release, hopefully at some point in their life. When they talk about that part of the ACLU lawsuit that refers to the application, clearly, I think that was one of the pieces they were addressing, how that photo was going to be applied. Many people will have their photos used and lifted on iStock and used at will, and they've signed off, given complete consent. It's clearly not what happened here. Now, the ACLU is actually serving, on this case, pro bono. They're not getting paid. But
Go ahead.
that's where you come in, David, but.
Well, there's a couple of different buts. There are attorneys who volunteer to take cases for the ACLU. They're doing those cases pro bono. Most cases that the ACLU take don't have a monetary award at the end of the day. You're looking for some kind of declaratory judgment or something to say, is this statute okay? Is that prayer banner okay in the school setting? That type of thing. There are, however, sometimes cases that ACLUs have taken on across the country that have produced a judgment or an award. And those lawyers have taken it pro bono. I don't think they benefit from that, but the money may go into some kind of fund to fund other kinds of lawsuits.
An interesting little wrinkle to this, as I was pursuing this for today, in fact, that the lawyer who was taking care of this particular issue said pro bono, yes, we're reimbursed out of pocket, but often when there is a pro bono case, if they lose, obviously there's no award, but if they should win, there's often an opportunity that even a pro bono lawyer can go back to the judge and say, I need some fees, which they might haggle, negotiate, or whatever else, and then split it with
Right.
the group, the body that they're representing, whether it was ACLU or someone else.
There are some statutes that allow for the awarding of attorney's fees. They're very limited, and I'm not 100% familiar with what was brought in this complaint, but I don't think that there's the ability to get an attorney's fee on this case. But I may be wrong, because I don't know what was actually included in the complaint.
Any other issues that you can think of relative to this? Because if not, the other somewhat related case, here in another little case in our state, the Cranston Prayer. We know how that as of this taping, that there may be an appeal, there may not be an appeal. Lawyers, they had done that as a pro bono. Are they likely to appeal, and is that worthwhile, unless they get another pro bono lawyer, of course?
Well, and I'm not a member of the ACLU, but the ACLU lawyers, I'm assuming, took this case pro bono. I don't think the lawyers for the city of Cranston are working pro bono. And I think that's part of Cranston's issue, is do we want to spend more money on this case, taxpayer money, to appeal what was pretty well-written decision by Judge Laguerre. If I lived in the city of Cranston, I wouldn't want them spending my money on attorneys to appeal that decision.
Nor would I, and I agree with you that Judge Laguerre made a principled decision, and that people in Cranston ought to go on to something else.
Right.
The issue right now about them having the right to remove that, do you think that it's worthwhile that they remove it, or is just covering that with TARP, does that cover the letter of the law?
Well, let's talk about what the whole thing is.
Actually, you should, I'll set
Okay.
up the first one,
All right.
David, your
Well,
turn.
there's this prayer banner that's been in Cranston since 1963, and it has a few words, not a lot of it, that could be considered religious. And I've heard people talking about this case, and it's not the banner itself, it's really what it stands for. And under the First Amendment of religious freedom, they talk about, well, the government, this isn't a violation of that, no one has to look at it, has to see it, has to do anything with it. But here's the thing. Rhode Island, of all states, was founded on the principle of freedom from having government tell you what your religion should be, or establishing a religion for the state. That is totally, this banner, totally against what we were set up for. We were set up for not having religion established for us or put on us by government.
Yeah, and the young man who made the banner with the prayer or the creed, he did it at a time when those words weren't even heard as religious, and he had the grace to say recently that I probably would have written it differently if I knew this would happen. And so the legalities here, and I defer to you, but I know the Supreme Court has had, the U.S. Supreme Court has had 2 cases involving posting of the 10 Commandments. One public posting was okay, and one public posting was not okay. And these are 2 different cases, and the reasoning was very complicated for each one. So,
Right, and it's actually boils down to, if it's a private school, you can do whatever you want in terms of having religion as part of your program, as part of things on the wall. It's government that's limited from that. And it's not that religion is bad or religion is banned or any of that, but those people who are out there complaining about this banner coming down and that we're interfering with having this religious thing up on a wall that's not very religious, and I agree it's not very religious, should take a look at it from another perspective. What if they were Catholic, but the school said all the teachers have to wear burqas? You know, the students don't have to wear it. We're not telling the students what to do, but people are going to be forced to wear burqas that work here.
Do you think that that's not just an issue of by degree, or do you think it's that black and white, David?
Well, I think it's black and white because once you step over the line, where do you stop? All right, there's only a few words in here. That's okay. There's a lot of words in here, but you don't have to say it. That's okay. Well, you have to say it, but you can say it to yourself if you want. That's okay. I think it's black and white. I think when you step over the line, you stepped over the line, even if it's just over the line.
I suspect editorially here, I'll make this comment, I wonder how many of those students had even noticed that that had been hanging there for years. They were probably oblivious to it until it has suddenly now been underscored and made national news, such as it has. On the appeals process, David, it's one thing if somebody did decide to do a case pro bono. Is an appeals process much more involved than even the initial suit?
Well, in this case, it would get appealed to the First Circuit Court of Appeals, I believe, and you're writing briefs. It's a lot of what's already been done because this case was tried with briefs and other types of things that were not live testimony, depositions on affidavits or whatever. It's a lot of work because you have to write the brief, then you have to go to court and argue the brief. A lot of time is spent on that. It's not an inexpensive proposition.
And the other legal question I wanted to ask, and I think it's somewhat relevant here, but from a business standpoint, said florist didn't want to deliver the flowers. Legal, not legal?
I think that's discrimination, and I think it's a violation of someone's civil rights. I don't think, if they don't want to deliver to some place because it's too far geographically, I think that's fine. Again, I go back to the civil rights movement. Was it okay to say that you can stay in this hotel if you're not black, or you can sit at this counter? We're not going to let you sit in this counter if you're an atheist. I mean, if you're dealing with the public, I think you're subject to all of the rules and requirements of anybody else who deals with the public.
And Froma, quickly?
Yeah, I would like to know the names of the florists who wouldn't deliver those flowers, and I will make a personal boycott of those people. I think that would be interesting.
It certainly would be. Well, I guess in the closing minutes, closing seconds, I wanted to thank you, Froma, for being our special guest today, our nationally award-winning columnist from the Providence Journal, and of course we always thank David Grasso and Odette Bizarre Cordero Grasso Law Firm in East Providence for bringing this to us. Hopefully these issues have been interesting to you, and hopefully will be helpful to you as you have an occasion perhaps to think about how your own rights are either defended or not so. And that also pertains to anything that's written in the press, whether it's editorially or advertising, political or not. I think we wanted to thank you, and we will hope that you will stay tuned as our discussion of legal matters continues.